Welcome to MOOC lecture. Today we will discuss anti-terror laws, implication on human rights and national security, offences against the state, offences against public tranquility and sedition. Terrorism in India has grown to a large extent in the last few decades. India is facing multifarious challenges in the management of its internal securities. There were various terror attacks in India. No civilized nation can accept this kind of barbaric inhumanity, partly or fully supported or sponsored by any neighboring country or domestic insurgents. The best possible way to combat it is to minimize, if not to prevent, the occurrences of such heinous crimes. Prevention is crucial, and hence anti-terror laws are a must to prevent such heinous crimes. Criminal justice system in India, particularly Criminal Procedure Code, was not designed to deal with such heinous crimes. Hence, it was a matter of paramount importance to legislate and enact different anti-terror laws so that those who are indulging in or abetting the terrorist activities can be given rigorous imprisonment. Various terror laws have been enacted in India since independence. Anti-terror laws are very effective to provide speedy trial as well as justice to the perpetrators of such inhuman, barbaric acts committed by those people. More so, after 26/11, there was a need to enact a much more strict and stringent anti-terror laws to tackle the menace of terrorism. Terrorism is the most heinous crime of the world. The term terrorism has been derived from the French word terrorisme, which is based on Latin verb terrere, that means to cause to tremble. The Jacobians cited this precedent when imposing a reign of terror during the French Revolution. In recent times, terrorism usually refers to the killing of innocent people by a private group in such a way as to create media spectacle. In November 2004, a United Nations Security Council report described terrorism as any act intended to cause to death or seriously bodily harm to civilians or non-combatants with the purpose of intimidating a population or compelling a government or international organization to do or abstain from doing any act. In many countries, acts of terrorism are legally distinguished from criminal acts committed for other purposes, and terrorism is defined by statute. The fact remains that at international level, there is no specific universally accepted definition of terrorism. Due to absence of any such universally accepted definition of terrorism or classification of inhuman barbaric act, it is a matter of paramount importance for a country like India to introduce and legislate anti-terror laws so that in case of occurrence of any such activities, then those activities can be distinguished and classified as an act of terrorism. In absence of any such law, the court of law would not be able to adjudicate and proceed, and the police as well as the law enforcing agencies would not be able to arrest the perpetrators of such crime. Hence, it is amply clear that without the existence of anti-terror laws, no administrative authority or judiciary can suo motu initiate proceedings on the basis of the discretion vested on them. Keeping this aspect in mind, various anti-terror laws have been introduced in India, and in this forum, we will discuss such anti-terror laws. After independence, various anti-terror laws have been introduced in India, such as Preventive Detention Act, Armed Forces Special Power Act, Unlawful Activities Prevention Act, Maintenance of Internal Security Act, National Security Act, Terrorist and Disruptive Activities Prevention Act, Prevention of Terrorism Act, etc. But in this forum, we will discuss mainly about Terrorist and Disruptive Activities Prevention Act, Prevention of Terrorism Act, and Unlawful Activities Prevention Act. The first law which was enacted in India, which is basically treated as an anti-terror law, is the Unlawful Activities Prevention Act. This act was enacted in the year 1967 by 16th Constitution Amendment. The Terrorist and Disruptive Activities Act as well as Prevention of Terrorism Act have already been repealed. Now let's start with TADA. TADA was introduced in the year 1987. The basic features of TADA were as follows. TADA defined terrorist acts as terrorist activities and disruptive activities. It put restrictions on the grant of bail and gave enhanced power to the law enforcing agencies to detain suspects and attach properties. The law made confession before a police officer as admissible as an evidence. Separate courts were set up to hear cases filed under TADA. But the main drawback of TADA was that any confession made by the suspects before the police officer could have been submitted as an evidence instead of court and magistrate. And that was the precise reason that after its introduction in the year 1987, TADA was repealed in the year 1995. Next, we will discuss about POTA or Prevention of Terrorism Act. POTA was introduced in the year 2002. After the hijacking of Indian Airlines flight IC 814 and subsequent attack on Indian Parliament, there was a need to enact much more strict and stringent anti-terror law to counter the menace of terrorism, and under such circumstances, POTA was introduced. Now we will discuss about the main features of POTA. Under POTA, a suspect could be detained for a period of up to 180 days by a special court. Law made fundraising for the purpose of terrorism as a terrorist act. A separate chapter was introduced to deal with terrorist organizations. POTA was repealed in the year 2004 after its introduction in the year 2002. Subsequent upon repealing of TADA and POTA, it was decided by Government of India that instead of legislating new anti-terror laws, the best possible way to fight the menace of terrorism would be to strengthen the UAPA and to convert it into an anti-terror legislation. For this purpose, amendments were carried out in UAPA in the year 2008, 2012 and 2019 to add some new provisions and chapters. National Investigation Agency is the enforcement body of UAPA. National Investigation Agency is also the counter-terrorism agency in India. UAPA deals with unlawful activities. Unlawful activities imply any action of any individual or organization with an aim to secession or separation or to question or disrupt the territorial and integrity and sovereignty of India. Now we will discuss the main features of UAPA. Under UAPA, following provisions have been incorporated. UAPA criminalized the raising of funds for a terrorist act. UAPA criminalized the holding of proceeds of terrorism. UAPA also criminalized the membership of a terrorist organization. It also criminalized the support to a terrorist organization and raising of funds for a terrorist organization. It increased the time available to law enforcing agencies to file a charge sheet to 180 days from 3 months. By the amendment of 2012, the definition of terrorist act was expanded to include offenses that threaten economic security, counterfeiting Indian currency, and procurement of weapons and arms, etc. The UAPA stipulates that any person who is a member of a terrorist gang or terrorist organization shall be sentenced to 10 years imprisonment under section 20 and 38 of the UAPA. In 2010, India became a member of FATF, or the Financial Action Task Force. FATF is an intergovernmental policymaking body whose purpose is to establish international standards and to develop and promote policies both at national and international levels to combat money laundering and financing of terrorism. Prior to 2010, there was no such law in India to combat money laundering and financing of terrorism. And to bring these unlawful activities within the legal framework, amendment was necessitated in UAPA. By the amendment of 2019, following provisions have been incorporated in the UAPA. Prior to 2019, UAPA had only been applicable to any terrorist organization, but by the amendment of 2019, individuals who were involved in act of terrorism were brought under the purview of UAPA. This change has been reflected in Section 35 and 36 of Chapter 6 of UAPA Act. Under this amendment, the government has been given power to designate and declare any individual or any organization as a terrorist organization. It is generally observed that after a terrorist organization is banned, a new organization would be formed by the members of erstwhile organization, or those members had started functioning independently. To prevent such a scenario, the above mentioned amendment was made in the UAPA. Another notable point in the amendment of 2019 is that the case of period of detention was enhanced. Section 43D of the UAPA Act enhanced the time limit for detention of a suspect up to 180 days if the investigation has not been completed. In case of a detainee under normal circumstances, Section 167 of Criminal Procedure Code is applicable, wherein the period of detention is 3 months. Third change, which has been made in the amendment of 2019, is the addition of fourth schedule in the UAPA. By this provision, the government has been empowered to declare any individual as a terrorist, and the same individual can be added in the fourth schedule. But there is no due process to add the individual in the fourth schedule. The only remedy which is available is that that particular individual shall approach to the government to denotify his or her name within a span of 45 days for exclusion from the fourth schedule. Now, we will discuss the scope of judicial review of the anti-terror laws which has been enacted and legislated in India. In the case of Kartar Singh versus State of Punjab in the year 1994, the Supreme Court of India maintained the constitutional legitimacy of TADA on the presumption that individual given such draconian statutory powers would act in good faith and for the benefit of the people. The Supreme Court also pronounced that the Parliament is competent enough to enact the said act under Article 248, read with List 1, Entry 97, and not with Entry 1 of List 2 of the 7th Schedule of the Constitution of India. After the case of Kartar Singh, TADA was once again challenged in the case of M24 versus State in the year 1996. In that case also, the Apex Court upheld the legal validity of TADA. After TADA, some provisions of Prevention of Terrorism Act 2002 was also challenged before the Supreme Court. In the case of Pupils Union for Civil Liberties and others versus Union of India. And under circumstances of the case, the Apex Court discussed the validity of the POTA and observed that the court has to maintain the delicate balance between the state acts and human rights, upholding the constitutional validity of the act. In 2019, two cases were filed before the Supreme Court, namely Sajal Avasti versus Union of India and Association for Protection of Civil Rights and Union of India, challenging the amendments made in 2019 in the UAPA on the ground that these provisions are violative of rights to equality, freedom of speech, and right to life. But both the cases are awaiting a hearing in the Supreme Court. Impact of anti-terror laws on human rights. Terrorism aims at the very destruction of human rights, democracy, and the rule of law. It attacks the values that lie at the heart of the Charter of the United Nations and other international instruments, namely respect for human rights, the rule of law, rule governing armed conflict, and the protection of civilians, tolerance among the people and nations, and the powerful, tolerance among people and nations, and the peaceful resolution of conflict. Terrorism has a direct impact on the enjoyment of number of human rights, in particular the rights to life, liberty, and physical integrity. Terrorist act can destabilize governments, undermine civil society, jeopardize peace and security, threaten social and economic development, and may specially affect certain groups negatively. All of this have a direct impact on the enjoyment of fundamental rights. Terrorism is the worst form of human rights violation. States have a duty to protect the lives of its citizens and the integrity of the state, and must be in a position to take appropriate steps to fight terrorism. There is no need to trade off between human rights and effective counter-terrorist action, as safeguards exist in the anti-terrorist laws itself. Terrorists are nothing but criminals, and hence states have every right to legislate anti-terror laws to protect the lives of its citizens and the integrity of the state. Next, we will discuss offences under the state. Offences under the state can be categorized into 5 categories under Indian Penal Code. The relevant provisions have been mentioned from section 121 to 130 of the Indian Penal Code. The first is waging war or attempting to wage war against government of India. Second one is assaulting high officials of the country. Third is sedition. Fourth is war against a power which is at peace with government of India or committing depredations on such power. And lastly, aiding or abetting or harboring a state criminal. Now let's start with the first point, that is waging or attempting to wage war against government of India. Section 121 of Indian Penal Code specifically mentions the punishment against a person or individual who ever wages war against the government of India or attempts or abets waging such war. In such a case, the individual shall be punished with death or life imprisonment or fine under the code. The relevant classification of this offence under CRPC is that this offence is cognizable, non-bailable, trialable by session court, and it also cannot be compounded. The relevant principle of section 121 is that no specific number of persons is required to constitute an offence under this section. The second thing is that the number and nature of equipments or arms are immaterial. In this context, it is important to mention that war, as stated in section 121, not to be understood with the international case wherein one country attacks another. Section 121 is not viewed as punishing prisoners of war of a belligerent nation. Then comes section 121A of Indian Penal Code. This section punishes the person who conspire to wage war against government of India with imprisonment for a term exceeding 10 years or with life imprisonment. To constitute a charge under this section, it is enough to show planning as the occurrence of the act. Classification of this act under CRPC is that it is also cognizable, non-bailable, trialable by session court, and also cannot be compounded. Then comes section 122 of Indian Penal Code. This section punishes anyone who collects men, arms, weapons or ammunition, prepares to wage war against government of India with imprisonment for life or a term exceeding 10 years and shall also liable to be fined. Classification of this offence under CRPC are as follows. It is also cognizable, non-bailable, trialable by session court, as well as it cannot be compounded. Then comes section 123 of IPC. This section punishes any individual who, by an act or illegal omission, conceals the existence of a design to wage war against the government of India, and in such a case, he shall be imprisoned for at least of 10 years and also liable to be fined. Then comes section 124 of Indian Penal Code. Section 124 of Indian Penal Code specifies that if any individual assault high officials, for example, President of India or governor of states, with intent to compel or restrain the exercise of lawful power, then that individual shall face a imprisonment for a term of 7 years or fine. The next point comes section 124A, that is sedition. This section mentions that any individual who by words, either spoken or written, or by signs, or by any visible representation or otherwise, brings or attempts to bring hatred or contempt, or excites or attempt to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life or a term for exceeding 3 years, and shall also liable to be fined. Thus, the two essential aspects of section 124A are bringing or attempting to bring hatred or contempt, or exciting or attempting to excite disaffection towards the government of India. Such act or attempt may be done by words either spoken or written, or by signs, or by any visible representation. The classification of this section under CRPC is that it is cognizable, non-bailable, triable by session court, as well as it cannot be compounded. The word sedition is itself a comprehensive term, and it embraces all those practices, whether by word or in the deed, which are adjudged to disturb the tranquility of the state and lead ignorant individuals to subvert the government and the laws of the land. Next, we will discuss about the constitutional validity of 124A of IPC. The Supreme Court, in the case of Kedarnath Singh versus State of Bihar, held that offence discussed under Section 124A of Indian Penal Code was not unconstitutional. The court believed that when it is construed that the words, either written or spoken, that have a pernicious tendency or intention or creating public disorder or disturbance of law and order, then it would fit the billing for a charge under this section. The court also held that a citizen has a right to say while he likes about the government or its measures by way of criticism or comment, so long as it does not incite people to commit violence or create public disorder against the government. Now we will discuss the present status of Section 124 of IPC. Honorable Supreme Court, in the case of S.G. Bhumbatkeri versus Union of India, in the year 2022, pronounced that all pending trials, appeals, and proceedings with respect to charge framed under Section 124A of IPC will be kept in abeyance. The Apex Court also directed that the state and central government will refrain from registering any FIR, continuing any investigation, or taking any coercive measures by invoking Section 124A of IPC while the aforesaid provision of law is under consideration. Waging war against foreign powers is covered under Section 125 and 126 as well as 127 of IPC. Aiding and abetting the escape of a prisoner of state is an offence under the Indian Penal Code, which has been described in Section 128, 129 and 130 of the Indian Penal Code. Offences against public tranquility is covered under Section 141 to 160 of the Indian Penal Code. Offences against public tranquility can be covered into 4 categories. Number 1 is unlawful assembly. Number 2 is rioting. Number 3 is promoting enmity between different groups or classes. And number 4 is affray.